I'm Professor Wallace. I'm chairman of the Institute. I welcome you. I've seen some of you before. You've seen me before. And if you've heard this talk, I begin by saying everything we are is Yonah.
The loudspeaker really is not picking up.
I don't think it is a loudspeaker. That's the trouble. Yeah, okay, well, why couldn't this be on the floor if that's all it does, and you can just turn it all the way up? Well, you'll all know that it's, hey, this is what we put up with, you know. But we love Yonah. I want the record to show that. This conference, this program is just an example of Yonah's work. And the note says this is about terrorism on the one hand and the rule of law on the other. And the rule of law really has two aspects. One is the law, the instrument of the law, used to deal with threats posed by terrorism. And Yonah lists a whole lot of things: that detention, prosecution, punishment, the International Criminal Court, etc., and so forth. And that's the law dealing with terrorism. And a lot of Yonah's work is that. For example, we are in the process of finishing a book on the Canadian legal structure, including all of its laws, dealing with the subject of terrorism in the broad. These are extremely valuable, I don't have to look here, resources. But of course, law also means the rule of law, the law that controls not just terrorists, but the governments when they deal with terrorists. And that's another subject of great interest to Yonah. In other words, that we, as everyone has said, we do not want to, the terrorists, quote, these are all, of course, generalizations, the terrorists win if we do the things that they wish us to do, which is to terrorize us into abandoning the things which we consider most central to our lives. And I'm a lawyer, I'm a law professor, and for many of us that is the rule of law. That's another little recording device, I gather. Okay. And Yonah is very much concerned with that too, that the battle to deal with terrorists should not compromise our liberties, our legal system, separation of powers. I'm a Republican, I might say, but I'm an admirer of Obama, and I admire his determination to close Guantanamo. Now, Guantanamo is probably irrelevant today in terms of dealing with terrorists. If you don't keep them there, you could keep them elsewhere. But in terms of the symbolism of dealing with terrorists in such a way as not to compromise our ideals, I would say that closing Guantanamo would help. And it probably will not happen if, but it's something to think about. At this point, my only last function is to introduce Yonah to you, our moderator. So, Professor Alexander, please. And Yonah, you're not to be fooled by this microphone.
Okay.
It's not relevant to us for some reason. Mr. Colon?
It's really intimidating of somebody looking at me.
Yeah, but exactly. And there are other and there are mics all around.
Thank you very much, Don. I'm actually grateful to Don for his continuing guidance, support for, I don't want to count, but it seems to me at least a few decades. And we still are dealing with the same issues, all the way from combating terrorism, and now war crimes is becoming very popular after 70 years since the end of the Second World War. We'll come back to it. Now, as Don mentioned, I mean, academically we try to deal with the security through law and the different aspects, the sources of law, the practice and all that. And finally, we were able to get courses, even at law schools, dealing with terrorism. I remember academically when I tried to study in this field and specialize, there wasn't even one course on terrorism, let alone on the legal issues. I studied international law. I was very fortunate to study at the University of Chicago with Professor Morgenthau and Quincy Wright, and then at Columbia with Philip Jessup. And so I got the best of the world, but no specific studies and courses. So we try to focus on that issue, particularly within the framework of conflict and war, the fog of war, so to speak, and again, this term is being used again and again. So the bottom line about our discussion today, and I will anticipate that this discussion will continue for the next at least a century, whether law and the rule of law is still relevant to our discussion. So Don touched upon some of these issues. Again, academically, we have to look at the broader picture, such as the role of the military. Everything is related really to law and the rule of law. We have projects on specific regions like Europe, Africa, Asia, and so on, and some horizontal challenges all the way from weapons of mass destruction, for example, the free zone idea in the Middle East and other areas, and then piracy, maritime security, aviation security, and so on and so forth. And obviously we have to work with international organizations like UN and NATO, and we have some activities in this area as well. Now, as a moderator, if I may have a couple of footnotes, and I think when we speak about a subject academically, we try to do two things. One, we're trying to learn the lessons of history, what works, what doesn't work in this connection. And secondly, we are trying to anticipate the trends in the future. We're not the prophets, but at the same time, on the basis of some data, by the way, open sources, I think we can reach some at least tentative conclusions. Let me just make one footnote on the anniversary dates of the month of April. And obviously, if you look at the calendar, I looked at the calendar yesterday, and obviously we have to always consider two challenges to our society. One is Mother Nature, of course, that tragically we don't have control. And now, obviously, we witness the terrible tragedy in the Nepal and the earthquake, and I'm sure that all of us express our sympathy and solidarity and so forth. And then, of course, many of us remember what happened with the challenge of Ebola, and it was a great deal of chaos at the time. So here is Mother Nature, then man-made. And we'll talk about man-made challenges. Obviously, we have this technological disasters, and I think now is the 29th anniversary of the Chernobyl tragedy. Now we have on top of it another tragedy in the Ukraine, but we'll discuss it later on. And again, if we look at the intentions and capabilities in terms of the so-called perpetrators or actors, on the one hand, state-sponsored terrorism is still alive and well and kicking. As we speak, we know what's happening not only in regard to Iran, Syria, as well as others, and of course weak states on no man's land, like the tri-border area in Latin America and all that. But what really came to my mind when I really looked at what happened in the past, and going back even 3 decades or more, in 1983, I'm sure that many of us remember the attack on the U.S. Embassy in Beirut, the car bomb, and so forth. And the question is, there is an incident, is there a response? And in this case, as we know, the United States withdrew from Lebanon, of course, the attack on the Marine base later on. So that's what happened over 30 years ago. Then if we look at the 1980s, 1986 attack on the disco in Berlin, and then this triggered, you may recall, an American response, but it was a military response to attack Benghazi and Tripoli. So the question is it permissible or impermissible? And this is the debate of the lawyers. Then we have, of course, the 20th anniversary of Oklahoma City, a terrible tragedy in the United States, and it caught many people by surprise. And then again, because of the attack in Oklahoma City, we did have the machinery of justice continue and operate, and McVeigh was ultimately executed. And then, of course, as we speak, the whole debate over the punishment in Boston with the marathon, it's about two years ago. So this is on the national level. And internationally, we have a long list also of lessons going all the way back, and we have a few diplomats here. And I'd like to mention, obviously, the takeover of the Japanese embassy in Peru in 1997, and we know what happened there in terms of the military rescue. What really is of a grave concern now that we see the different manifestations of terrorism. We're going to discuss it in terms of the outlook for the future and the assessment, but really, even in the past month or two, the escalation of attack on Christians and Christian minorities, whether in Egypt, the Coptic Christians, or the attack of the ISIS in Libya, or more recently the attack on Ethiopian Christians as well. And we can go on and on in terms of the different manifestations, the attacks on minorities in Africa, all the way from Nigeria to Somalia and the Middle East and elsewhere. Now, whether or not I remember very vividly the University of Chicago, really almost over 50 years ago, when we discussed international law, and there were people who thought that we're talking about a system that does not work and broken, but I can assure you we had to study for a PhD in international law. And now we see, I mean, a great deal of activity as we speak, and I have a few colleagues here I see in the audience who are interested in the weapons mass destruction. As we speak now, there is a meeting going on at the United Nations on the NPT review conference. As you know, this is the Treaty of the Non-Proliferation of Nuclear Weapons, and they're going to speak and to discuss it for a couple weeks now in terms of the implementation of this treaty and the provisions, and many countries are obviously concerned about this. And Don just mentioned the International Criminal Court and that idea. And for example, the chief prosecutor of the International Criminal Court, he spoke just recently, and he mentioned that he is receiving many reports related to the cruelty in Syria and Iraq, the so-called Islamic State or Caliphate. But he indicated that the court has no jurisdiction whatsoever over these countries and the leaders, and therefore could not seek a prosecution. And the prosecution can proceed provided that the United Nations Security Council, for example, would conduct or ask the court to conduct investigation, or if, let's say, Syria and Iraq will accept the court jurisdiction even on a temporary basis and so forth in order to investigate crimes as war crimes and so on. So these are some, I think, of the issues that we're going to discuss. Sharon, did you have some slide or something like that quickly? Now, in my mind, when we talk about terrorism, and I would like to get your reaction, I think not only that it is global, and we know that, but when we were in Syria, and I see some people here that we were in Syria at the time, a Syrian actually cartoonist who provided that report or slide. So I think when we talk about weapons, the most dangerous weapon is man himself. And that's what it is really all about. We have to discuss it next. And of course, we have to sympathize with the victims. As we know, we try to always to do that next. Again, any country, for example, if we look at Africa and the link with the so-called Islamic State, every day we have some claim of allegiance to the caliphate in that region and elsewhere, all the way to India and so on. So we have to keep this in mind, that no country is immune, and the question is, legally, what can the international community do about it? Next, quickly. Now, I always raise this question, I think key questions, because when people ask me whether the worst is yet to come, and my short answer is always definitely yes. It's not if and when. It's a question of when and with what impact. And then again, we're very concerned for decades with the escalation of the biochem, radiological and nuclear. And in fact, we do have now a project with some leaders in the United States and internationally on biodefense. And I think that this is something we have to pay very close attention. Okay, so at this point, I would like to introduce a very distinguished panel. You have a bio on each speaker, so I won't go into it except to say that we do have a very, very distinguished panel. And Professor Paul Pilar, who really spent almost 3 decades in the U.S. intelligence community, and he has also extensive experience in the academic work, also teaching at Georgetown and publishing some definitive books in international affairs, also working with Brookings and other institutions. And also, he knows what war is all about because he served in Vietnam. So Paul is going to provide some sort of a context to our discussion. You want to come here or whatever is good for you? Okay.
Thanks, Yonah. I come at this from the perspective of a counter-terrorist consumer who is not himself a lawyer. I worked on that topic for a number of years in government service, and then have looked at it from more an academic perspective since then, when I haven't really been a consumer of legal advice as I was when I was in government service, but still as someone who appreciates a good, clear legal position with regard to the issues that come up. And not to try to start this out on a negative note, but I want to put out as my main point this afternoon that there is a challenge and a problem in inconsistency, as I see it, in which we collectively, this is the broad we, have drawn on peacetime and wartime legal frameworks as ways to think legally about terrorism and counterterrorism. Each one of those frameworks is quite internally consistent and has served us well in many other contexts other than terrorism. The problem is we have wound up selectively picking from one or the other in a way that I think overall has not been consistent. And I don't blame lawyers for that. I think the problem began with the application of the war metaphor to counterterrorism, specifically in the immediate aftermath of 9/11, for reasons other than legal reasons. The "we are at war" cry, served other purposes when the lawyers were not consulted. One, it's simply an exhortation, an expression of importance of the topic, we need to do more, so on and so forth. And secondly, it became a kind of code word for those who wanted to express a preference for using the military instrument in the name of counterterrorism more so than other instruments, diplomatic, financial, and so on. You even heard people, especially in the immediate wake of 9/11, throw out a false syllogism saying, well, this is an important problem, right? That means we're at war. And if we're at war, right, that means using military force, right? Well, you see, the logic doesn't actually quite flow, but that's in effect the way a lot of the thinking went. And those, the real lawyers who had to, clean up the mess have had, I think, a mess to clean up. We Americans have had, traditionally more so, I think, than other people, a feeling that there are clear distinctions between time of war and time of peace. It's part of our a sort of broader black and white thinking that other people aren't necessarily as prone to as much. I don't want to go into the whole background of that. But the distinctions when it comes to terrorism aren't nearly as clear as we Americans like to think. And the proclamation that we are at war after 9/11 really did not take into account some of the blurriness in the distinctions. A pertinent observation, I think, relevant to what I've just been saying is that if you look at what terrorism is and how it's been defined by both a lot of the scholars who have followed it and even some of our official U.S. government definitions, some of the most inherent aspects of terrorism involve violations of the laws of war in at least a couple of respects. One is, terrorists do not wear uniforms and insignia in the way in which an armed force under the laws of war is supposed to be clearly identified as a military force. Stealth is instead the usual method. And another obvious respect is attacking civilians, which gets right to the essence of terrorism. In fact, some of our U.S. government definitions talk about attacking non-combatants, which aren't always civilians, but it gets to the idea that this is something different from battle waged between uniformed forces on a battlefield. Well, terrorists attack civilians. That's a violation of the law of war. The fact that others violate the law of war, of course, is not a reason for us to violate it, and we don't, and we not intentionally, but I think our picking and choosing between peacetime and wartime frameworks does raise some legitimate questions. We have referred to a wartime legal framework to justify many of the things that we do, including but not limited to use of military force, but we haven't gone fully in that direction. People we capture on battlefields and other places, Afghanistan and so on, we haven't called prisoners of war as they would be defined under the laws of war. We call them something else, illegal combatants. So we're still in this netherworld between peacetime and wartime. I think major aspects of the current international terrorist threat, especially as it has evolved in recent years since 9/11, takes us farther and farther away from the types of clear armed conflicts and confrontations to which traditional law of war clearly and most neatly applies. And let me mention three respects in which that point is true. You have an indefinite nature of the entities or organizations that we are combating. In the immediate aftermath of 9/11, at least it made some sense for those who said, well, we're at war with al-Qaeda, the group that did 9/11 and a few other attacks against us. And that made more sense than a war on terror. At least this was an entity. But since then, al-Qaeda itself has metamorphosized into something much vaguer, harder to delimit in terms of what kind of organization is. We still have Al-Qaeda Central in South Asia, the guys hiding out with Zawahiri somewhere along the Durand line. But they're actually not the main threat these days. It's more the so-called affiliates in places like North Africa and the Middle East and elsewhere. And some of those, but not all of those, have adopted the Al-Qaeda name. The name doesn't really tell you whether it's part of a larger organization or not. And then you have all the onesies and twosies and threesies and cells in the West and so on, with individuals who express varying degrees of affiliation to or allegiance to or admiration for an organization like Al-Qaeda. And now we've got ISIS or Islamic State, which started out as one of those affiliates of Al-Qaeda and then broke with it. And now we've got other sort of entities, including those onesies and twosies and threesies on various continents that express various degrees of affiliation to ISIS. How do you make sense of this in applying a legal framework that was devised with much clearer entities in mind? We're making war against Germany or against Japan, or even in the case of internal conflicts against a specific guerrilla or insurgent movement, which is a lot better defined, even though it's not a nation state, than the sort of thing I'm talking about. So that's indefinite organization. Secondly, indefinite geographic limits. We're talking about a phenomenon we're combating that ranges across the world and blurs between domestic and international realms. And that fact that it's gone across the domestic and international has been one of the big problems when we get into some specifics, one or two of which I'll mention in just a moment. And finally, there isn't really a limit in terms of time. Again, especially here in the United States, we think of clear distinctions: wartime, peacetime. We even though we don't declare war in Congress these days anymore, we have certain specific openings, like when we, there was a particular date when we began the war in Iraq in 2003. And we speak in a lot of these problems having to do with handling terrorists in terms of what we're doing for the duration. What we're doing as long as we are combating terrorism, or as long as we're waging a so-called war on terror. But as even some of our leaders, like former Defense Secretary Rumsfeld, have told us, we're not going to have a clear ending to anything here. My argument is we don't have an ending at all. Terrorism has been around for millennia, so will counterterrorism. But even in the sense of counterterrorism as being a major U.S. policy preoccupation, we're not going to have anywhere near a clear distinction. So what does that mean in terms of any kind of shift between wartime and peacetime legal frameworks? So we've got a series of problems that I think are still unresolved, and just to name several, and I'm sure we'll have more discussion on this. One concerns congressional authorizations for the use of military force. And I think it was good that the administration sent a draft to Congress, a few months back. And I agree with those who say that, the old resolutions, the one right after 9/11 and the one before the Iraq War, these really don't carry the freight in terms of what we're doing, including doing with military force and counterterrorism. But Congress seems most recently just to kind of sort of given up on this. They're asserting themselves vigorously on this Iranian nuclear thing, but the last reports I've seen is the AUMF just isn't going anywhere. And we can think of other political reasons for this, but I think the main reason is it's real hard to come up with a resolution that would really get around all those problems I've described, that would authorize the president to do what he needs to do to combat terrorism, but would place meaningful limits in a way that would make the resolution meaningful. So that's one problem. Second one is what was already mentioned by Professor Wallace, and that's Guantanamo. And like him, I share admiration for the president for trying to do something about this. He pledged to close it in a year. He wasn't able to meet that pledge, and of course we're way beyond that time limit. And I think part of the reason why it'd be good to close Guantanamo is not just the overall image it's had, but getting back to the issue of rule of law, ask yourself, why was that particular location chosen for this detention facility? Was it to give the detainees the cooling effects of Caribbean sea breezes? Of course not. It was picked as this sui generis spot, a long-term lease of a military base in a country that, with a relation headed by a government that we don't even have diplomatic relations with, although we might soon. And the idea seemed to be to keep it out of the reach of anyone's law, you know, U.S. law, Cuba's law, or anyone else. That is not, I think, a very good statement about counterterrorism and the rule of law. Another problem, which flows from Guantanamo, the military tribunals. And I would assert that as we look at the sort of shakiness with which that institution has tried to get off the ground, their creation, in the eyes of many people, is a matter of making, to put it quite bluntly, an ideological point, you know, that we are at war, and none of this civilian stuff when we come to counterterrorism. Even though, as a practical matter, relying as we have for many, many years on the Article III civilian courts, especially those that are most experienced in dealing with terrorism cases, like the Southern District of New York, where our new Attorney General comes from, I see no reason why the tribunals had to be created in the first place, and why those other courts, which have served us well, couldn't have served us in this case. Another area, surveillance and intelligence collection. And here I would just point out that the main reason for all these controversies we've heard with regard to the NSA activities and so on is one of those indefinite matters I mentioned before, the blurring between what's domestic and what's international. And here we're getting into the technological fact of how a lot of the stuff that NSA would usefully collect in terms of foreign terrorist communications flows through switches or cables or whatever here in the United States. And that's how we got into this whole business, part of the reason we got into this whole business of what's considered domestic collection. And finally, I would mention as a particularly sticky point, the issue of extraterritorial execution, if you will, of people and specifically U.S. citizens. And I think what particularly puts this into a very disturbing framework is this most recent case of a person who reportedly, an American citizen, was on one of these hit lists, or at least he was this target of a lot of discussion within government circles as to whether he ought to be the target of a drone strike when he was still off in South Asia or wherever he was. But then he was captured, and now he's in U.S. custody, and he's being brought to trial in a U.S. court, which greatly weakens, of course, one of the rationales for the extrajudicial execution of an American citizen, that is that we have no other way of reaching them, and we can't bring them into a court. I think this is a very disturbing issue, and we aren't close to a solution on that. So my overall conclusion in this is, I think we've expected too much from the lawyers, who have done as well as they can in trying to maintain the consistency of peacetime and wartime legal frameworks. It's we as a public who have imposed unclear and inconsistent rhetorical, political, and even at times intellectual frameworks that has resulted in these difficulties that I described. Thanks.
Thank you very much. Thank you very much, Paul, for raising some very important issues. Obviously, we'll go back to it, and after the presentation by members of the panel, we'll develop some discussion. Now, it gives me great pleasure and honor to introduce Dr. George Carlosville, who is the Deputy Chief of Mission of the Embassy of Georgia. Part of our academic work draws from the experience and knowledge and wisdom of diplomats serving in the United States and around the world, and we see it as a two-way street, meaning on the one hand, diplomats and diplomatic missions and sites were selected by other governments and by terrorist groups as targets over the years, and they were victimized. And then, of course, we had to deal with those diplomats whose countries were invaded or attacked, and this is a case study in regard to Georgia, and we had the ambassadors from Georgia right here dealing with that, and also in Tbilisi. And I'm delighted that the Deputy Chief of Mission is not only what we say, a true diplomat and a professional, but also an academic. He earned his PhD at Oxford University and was also a professor in teaching. And I asked him to actually to discuss any of these issues related to our topic. So would you, George, come up here, or whatever is better for you? I think we have this camera that we're trying to get the record.
Well, thank you. Good afternoon. Let me say from the beginning that I did not coordinate what I have to say today with our Ministry of Foreign Affairs, so please treat it mostly as my personal opinions, even though I tried to fit it into the wider understanding of Georgian view of international law and regional developments. I should first of all thank Professor Alexander for inviting me here today, and also to the Inter-University Center for Terrorism Studies and International Law Institute. And the purpose of my talk today is to discuss the place of, or vague place of international law in the context of recent developments in the Caucasus and adjacent areas, which I will henceforth call the region. Geographically, Georgia is a good place to observe the dual challenges to the world order or the international system of states. First of all, Russia in the north tries to superimpose its own rules in the neighborhood, altering the borders of the states by force, and neglecting various fundamental international agreements. And second, terrorist Islamic State fighters in the south from Georgia try to overthrow the fundamentals of international law. In a sense, if I may say so, both of them are kind of imperial encroachments on the contemporary state system, not only by principle, but also by the weapons they deploy. From the legal perspective, there are some resemblances between terrorism and the so-called hybrid warfare that we have seen in the region, not only with respect to Ukraine from last year, but also with respect to Georgia as long as 25 years ago, 25 years ago, in Abkhazia and so-called South Ossetia in the beginning of the 90s. So these two challenges in the north and in the south, respectively, epitomize two aspects of the same process, which is the erosion of the contemporary international system. So first I will briefly provide the historical overview, very briefly, of the challenge for Georgia and the region, and then I will discuss the essence of the ISIS challenge for Georgia and the post-Soviet space. And my main argument here is that the ISIS, in particular, represents a familiar threat to our region, including in international legal sense, but on a larger and more dangerous scale than before. This new threat is the menace of establishment of a faction of an Islamic State in the region. And then I will focus on Georgia's policies of tackling the threat of terrorism, including its legal aspects. I'll conclude with some thoughts on the future of the challenge of terrorism for Georgia and the larger region. So first, history. Terrorism came to the region in its explicit form, in a form of Islamic radicalism in Chechnya and the adjacent regions in the late 90s, especially after the start of the second Chechen campaign by Russia. I would say that the oncoming of radical Islam and terrorism was due to the Russian campaigns in Chechnya throughout the 90s, when large numbers of traditional ethnic Chechen nationalists were wiped out from the region, thus giving way to more Islam-centered resistance to Russia, as opposed to nationalist resistance to Russia. So Georgia's Pankisi region borders with Chechnya and is mostly populated by ethnic Chechens called the Kist, with Georgian surnames, but they are Muslims, unlike Georgians, and they mostly confess local version of Sunni Islam. After the start of the Second Russian-Chechen War in August 1999, along with many refugees from Chechnya, several dozens of Chechen international fighters crossed into Georgia to find the refuge from advancing Russian armed forces. By 2001, there was a dual danger of Pankisi becoming a hub for international terrorism that would invite Russian invasion in the province under the pretext of fighting international terrorism. Potentially, this could become the third province of Georgian territory controlled by Russian forces, after Abkhazia and Tskhinvali region, so-called South Ossetia. Georgian government under President Shevardnadze, with the United States cooperation under the Georgian Train and Equip program, trained anti-terrorist forces. This act helped to ease the Chechen and international fighters out of Pankisi and subsequently returned the province under the control of Georgian authorities. In follow-up training sessions, the United States prepared more Georgian troops for participation in the peacekeeping operations in Iraq and Afghanistan. Currently, under the Resolute Support Mission, Georgia provides second largest contingent of troops in Afghanistan. With the current advance of ISIS, Georgia and the wider region faces a new wave of terrorist threat as the ISIS is expanding its reach in the Middle East and also further to the north. Numbers of young men from the Caucasus and Central Asia, as well as Russia, travel to Syria and Iraq to join the ranks of ISIS. Some of them are presumably from Georgia. By different estimates, there must be around 4 dozen Georgian citizens fighting in the Middle East. Apart from the obvious threat to regional peace and security, ISIS poses threefold challenge to Georgia in security, political, and legal senses. First, return of these fighters in terms of security poses a security threat to Georgia's stability. Second, since they represent an ethnic minority in Georgia, the returned fighters' persecution may become a political issue. And third, their prosecution for war crimes is a legal challenge that is being dealt by Georgian authorities, and I'll talk about this later. Then, what is the particular challenge coming from the rise of the ISIS in the Middle East in the context of the Caucasus? In past decades, political and security challenges to the region emanated from three sources. First, Russia's efforts to dominate the post-Soviet space and establish its exclusive sphere of influence. Second, from ethnic separatism and irredentism, which has been encouraged and cultivated by Russia in neighboring states. And third, from international terrorism. Potential spread of the influence of ISIS represents the third kind of challenge, international terrorism. Arguably, ISIS is developing ties with the so-called Caucasus Emirate, which was established in 2007 in Chechnya. The Emirate is employing terrorism as its major weapon, and some of its commanders recently switched their allegiances to al-Baghdadi and the Islamic State. It seems that the ISIS is gaining some clout in the North Caucasus. The threat is not unseen in the North Caucasus, though, as there were connections between the North Caucasian fighters and Al-Qaeda in the 2000s. And there is very little difference because despite the name, of course, the Islamic State is not a state in classical sense, and it cannot be understood as, and its fighters cannot be understood as a side of the war, a party to the war. What is different with ISIS is the scale and determination to establish a caliphate with extension to the Caucasus and other regions of the world. There is a serious danger to regional peace and security in the Caucasus, which has been torn in the past decades by numerous interethnic and even interstate conflicts erupting or threatening to resume. So Georgian government finds itself in a difficult situation, facing the twofold threat from Russian aggression with occupation of Georgia's two territories in Abkhazia and South Ossetia, and the dangers of higher scale resurgence of Islamic radicalism in the North Caucasus, and by extension in Georgia's Pankisi province too. There are measures that the Georgian government has undertaken to tackle the problem. The government initiated amendments to the law prohibiting participation of Georgian citizens in unlawful military formations overseas. These amendments aggravated punishment for calling for participation and actual participation in such military groups outside Georgia in order to prevent their involvement in terrorist activities internationally. Georgian law enforcement services fully control the situation in all Georgian regions where suspected terrorists may be migrating back and forth, except for the Russian-occupied 2 regions. So Georgian government, unfortunately, is unable to control those 2 regions, Abkhazia and South Ossetia, and they may potentially be safe havens for various clandestine activities. As I mentioned earlier, the problem with these outside terrorists and hybrid warriors dates back to 1992, when scores of Russian citizens infiltrated Georgia under the disguise of volunteers that cannot be treated as either criminals or the warriors of any particular side. I remember there was a Georgian politician who suggested to declare a war on Russia, in which case there would be some legal grounds to deal with these fighters incoming into Georgia, and he was, of course, duly ridiculed. But this episode, this anecdote, exemplifies the difficulties associated with international legal treatment of the status of various terrorists and fighters in the region. So Georgia is also a member of the anti-ISIS coalition led by the United States, actively participating in coalition meetings and coordination worldwide. Also over a decade, Georgia has been participating in international peacekeeping missions in the Middle East, Afghanistan, and even Africa to gain experience for battling homegrown and international terrorism. Georgia is an active participant of international anti-terrorist networks and initiatives. In particular, Georgia has a very effective mechanism for implementing the UN Security Council resolutions, particularly the Resolution 2178 of 2014, condemning violent extremism. Mostly this focuses on asset freeze, travel ban, and embargoes. Georgia hosted also Guantanamo detainees over years to facilitate United States efforts to reduce the threat of international terrorism. So a few concluding remarks. While individual cases of terrorist threat can be contained, the ISIS challenge to the Caucasus is greater than Al-Qaeda used to be, because the latter can sprawl its territorial, because ISIS can sprawl its territorial offshoots all over the region with a serious potential for regional destabilization. In our region, anti-terrorist coordination is difficult because of existing among the regional countries, because of existing interstate and intrastate tensions. These tensions allow terrorist groups to exploit differences between the countries in order to gain their foothold in the neighborhood. Respect for international law must be restored. For Georgia, the priority is deoccupation of Georgian territories by Russia and restoration of Georgia's territorial integrity in internationally recognized borders. This would lead to the restoration of trust in the Caucasus, leading to more effective measures to tackle the challenge of international terrorism. Thank you.
Thank you very much. We'll come back to many of the issues that you raised in terms of state involvement as well as sub-state. And everybody is focusing on the Middle East, but many are unaware of the volunteers coming from that particular region or being trained by some of the so-called warriors from that region. But at any rate, we'll come back to it. It gives me great pleasure again to introduce Professor Mir Sadat, who is a professor of national security and Foreign Policy at the National Intelligence University. Like some of the other participants, he has very extensive government experience, providing advice to some of the military staff, such as General John Allen and the ISIS group in Afghanistan, Kabul, but he has also experience in Pakistan and elsewhere in the Middle East, and also military experience as a Naval Reserve attaché officer and so on. Academically, I know that he taught at quite a number of universities on these topics. And what is really interesting about his background, I don't know how many of you remember the very profound films, the Charlie Wilson War and the Kite Runner, that they provided advice to the film production. And he has also some business background as well. Mir, it's all yours.
I was not going to break with tradition and speak from where I sit. Gives me great pleasure. I'm deeply humbled to be among such a great panel. I want to thank Professor Wallace for hosting this event, and of course, Yonah, thank you. I'm going to look at this. I'm not a lawyer, so I'm looking at this more from a political and policy perspective, and integrating some of sort of my experience having served in government and then some of the hot zones, and having actually had those discussions of what approach do we use on a particular problem set. I think Professor Pillar knows this very well, and maybe some of the other colleagues, that I don't speak on behalf of the United States government, any entity, whether it's Department of Defense, the Office of the Director of National Intelligence, or any other United States government. These are my views and my views only. I'd like to keep my clearance for as long as I could. I think it's important in reaction to the recent sort of what we term now as lone wolf terrorist attacks in Europe. Some of our European colleagues are reacting in defense of their national security, in defense of their civil societies. And if you look at some of the legislations and some of the proposals that are being proposed, these anti-terrorism measures, they're pretty strong and I would say stiff. They can isolate suspected terrorists. They can revoke their passports. They can actually come to your house and take away your passport. They can shut down websites that purport or supports even superficially terrorist groups. And it's interesting that the wall between the law enforcement community and the intelligence community in some of these European countries and the European Union as a whole is sort of breaking down as a result. And I do not think that in the United States that's necessarily happening to the extent that the Europeans are proposing. But as Professor Pillar said, we are living in a society in the United States where surveillance of whatever measure, whether it's law enforcement or intelligence community, is still going on. The employment of drones, targeted killings, as they're being termed as, and also the debate is still raging over interrogation. What is torture? What is enhanced interrogation? And were we right? Were we wrong? What's the future going to hold? There's some of the concerns that will follow you in this debate. Definitely privacy violations. So whose phone are we tapping? Whose internet accounts are we tapping? And
if you spoke with someone who was affiliated to some member of Al-Shabaab, are you an affiliate or an associate, and can we still continue to follow you? There's an idea that there might be disproportionate amount of control vested in the state and the intelligence community that's working alongside the law enforcement. And maybe discrimination. You know, I have a name that is Middle Eastern, so will I fall into one of these databases? Who knows? And potentially, if this continues, which is feeding into the narrative of ISIS and Boko Haram and all of these groups, that the idea of being innocent constitutionally before charges are even brought up against you, these might be coming into question, right? So these are things that we have to keep in mind. At the same time, it's important that we prevent and combat terrorism, right? And we need a competent, independent, impartial criminal justice system. You know, for the most part, that's rooted in whether it's the international norms or our norms of what human rights are, right? Each country has to determine that for themselves, and the rule of law. So these are the two sort of sides of the coin. We know through various types of empirical data that rule of law, a well-functioning criminal justice system increases public confidence and trust in state institutions, thus enhancing the state's ability to combat terrorism. Rule of law is crucial for any democratic or democratically inspired state or nation. But democratic societies attract transnational movement of goods, products, people, as Professor Pillar said, that potentially terrorist activity, right? So how do we combat these? So my question to you, and maybe we can get into a discussion, is are Western democracies, when we talk about Western, I'd like to include Australia into this as well, are we heading down a state of terror or fear, right, and vulnerability of the average citizen is making it readily available for me to give up all my freedoms? Because I would like to walk down the street or down the Washington Mall with my family and not fear that a guy who's wearing the backpack, right? Am I going to say, take all of these freedoms so I can enjoy my life? I really love my life. Or are we going to shift back to an idea of state of law, which where we educate the community on the values of what rule of law is, adherence to rule of law, the idea of diversity, the idea that we're one society, and we try to bring in some kind of social and political inclusion. Where are we at? Where's the litmus test here? And then how do we apply this to societies that are not like us, that are still on the path to democracy? And they're being asked by us to combat terrorism, but their institutions are not fully developed. Their rule of law is not developed. Their legal systems are not. Their criminal systems are not independent, impartial, and corruption is entirely pervasive in the system. So the weakened, morphed view of rule of law exists in the Middle East. So let the Middle Eastern state might say, let me combat terrorism, but you need to let me do it my way. And I might have to infringe on those human rights, on those rules of privacy. So what does that do? Does that create more grievances and inspire more terrorists? The recent events in Yemen highlight such a failure in counterterrorism. The institutional society reforms are halted. The respect for rule of law does not exist. When you don't respect rule of law, the terrorists are not, or the population is not going to, be inspired to respect it either. How do you bring people how do you win people over? All right, that's the major piece. But you are faced with apprehending suspects who are out to kill indiscriminately government employees, military personnel, and civilians. And of course, during this confrontation, collateral damage happens and casualties happen. And at times, in some of these countries, suppression of the public's freedom, journalistic expression, and thought. So, did we actually win? Or are we heading towards winning? Or by doing this, did the terrorists win? And this is very ambiguous and very generalized. So, there's no doubt in my mind that some of these political protests and violence that occur are, like what was said earlier, a result of grievances, right? Like in the Chechen model. So, is the response to it to deal with the grievances and the complexities of the issues, or is it to just stomp it out? You know, kill whack-a-mole. Try to root it out that way. So I definitely do agree with Professor Pilla that when democratic societies want to protect their citizens against new threats, these threats that are no longer the us versus them, the bipolar or tripolar world of major powers, but you have a world where you live in Al-Qaeda affiliates, Hamas, Boko Haram, next, who's next, right? The old rules and designs of the game are no longer functional for this convention. That conventional warfare cannot be utilized. New balances must be struck. And when we are striking for that, we must make sure that the countries that are the front lines to these terrorist apprehensions and confrontations, that we do not weaken their system by asking them to do things that actually undermine their own institutional and societal progress. I have a couple of notes that I jotted down as people were talking that I also want to elaborate on. That when we talk about this idea of Guantanamo Bay is an interesting phenomenon, right? The question is evidence and intelligence. So when you are dealing with rule of law and counterterrorism, and you're dealing, for example, the FBI is, intelligence does not equate to evidence. So sometimes on the battlefield, when we do pick up someone, and there is great intelligence that this person is very, very much involved in this deed, that does not necessarily translate to evidence. So how do we get out of this dilemma? And how is it possible to share? Will our laws allow us to share? Are we heading down that road, right? When we are looking at some of these societies, what's the purpose? Is it rule of law? What's the strategy for Syria, for Iraq? Rule of law, stability, democracy, end of dictatorship, or just containment? So, you know, there's a wide spectrum here. How are we looking at the problem set? And when we're looking at groups like ISO, they have a professed ideology, which is definitely the caliphate, the Salafist version of caliphate. But when you look at their actual ideology, it's very criminal. So if we're going to counter them, do we counter the professed ideology, or do we counter their behavior? And can we counter their behavior? Can't counter fire with fire, right? So we're limited in that aspect. So how do we counter ISIL? And the important aspect is, so we don't recognize the Taliban that we capture on the battlefield under the Geneva. We would call them enemies on the battlefield or enemy combatants, because the minute we give them that credence, we've recognized the movement as a legitimate movement or as representative of the state. So that backfires too. So we're in a unique quandary here. And so the other question that was brought up was the extraterritorial target lists or targeting. So, when we target Zarqawi and we take him out, one question is the U.S. citizenship aspect, right? The second piece is how well are we supporting the institutional systems of that nation to go after terrorists in their own country? how do they look like to their population? Will their population now respect rule of law? So a very quick anecdote also is important to bring into this aspect is the idea of rule of law. In 2008 or so, the Taliban rolled into the Swat Valley of Pakistan. And the Swat Valley was not necessarily very appreciative of the Taliban, but they opened their arms and they let them in. And the problem was that the Pakistani judiciary system was utterly incompetent and corrupt. And for someone to get just a business transaction through the system, it would take years. The Taliban were very transparent and very swift. And it was something that people actually could, deal with easier, right? So how are these organizations doing with establishing their own legitimacy of rule of law? And once they have, how well is it to replace that and say, that rule of law that you're used to under ISIL now, right, is not the right one, and I'm going to give you a new one. And the other, my final thought I want to leave you with is, so when we talk about the Salafists, the jihadi Salafists and others, we have to distinguish a couple of categories. We have what they term the quietist Salafists. It's their ideology, it's their way of life, it's their internal viewpoint. We have sort of the Ikhwan, which is different than Ikhwan al-Muslimin, the Muslim Brotherhood. It's the political ones where they will sit down and discuss and there'll be heated debate. And then you have the jihadi ones. So as we are looking out towards ISIL and other threats who are mainly coming from this type of denominational lens, how are we distinguishing the various factions? Because definitely the jihadist one wants to impose a different rule of law, right? A different set of orders. Whereas the Ikhwan wants to debate that with you and potentially negotiate with you. So with that, I'd like to close and thank you, and also repeat my disclaimer that these views are mine and they don't represent the United States government. Thank you.
Thank you very much, Mayor. As I indicated, we'll have a chance to pick up some of your point and your experience, not only in the Middle East but in South Asia. Now, our next speaker is Hassan Saliba, who is a senior foreign law specialist for the Middle East and North Africa at the Law Library of Congress. Obviously is an attorney, and I don't think there are many attorneys who have both the Beirut and the DC bar. So he served with great distinction at the Law Library in Congress, but also provided some advice in the Middle East and elsewhere. And academically, I'm very proud that he supports our academic work in this very complicated field. Islam?
Good afternoon. I also shall note that I am here in my personal capacity. Opinions I express and statements I make are strictly mine and do not represent the Library of Congress or any other U.S. government institution. I'm going to speak only about one issue, and that is whether terrorism can be treated as an international crime, like war crimes, like genocide, and like crimes against humanity. In 1937, the League of Nations adopted the first multilateral conventions for the prevention and the punishment of terrorism. Article 1 of that convention defines acts of terrorism as criminal acts directed against a state or intended to create a state of terror in the minds of particular persons or a group of persons or the general public. Now, this convention has not been ratified and never entered into force. Attempts to adopt a substitute treaty have been frustrated since. The United Nations member states are still unable, for several years now, to move forward on the draft Comprehensive Terrorism Convention, which requires acts of terrorism to be intended, like the first convention, to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. Now, the main stumbling block why the world community is not able to agree on a convention is the problem of defining what terrorism is. Now, this is despite the existence of many definitions crafted by distinguished scholars in the field, among them one offered by Professor Alexander. I don't know whether you saw it on the internet. I will give it to you afterwards. Now, unless we can define terrorism in terms of a criminal law language, there is no way that we can treat terrorism as an international crime. In United States versus Yusuf, the U.S. Appellate Court, the Second Circuit, ruled in 2003 that terrorism is not an international crime that can give rise to universal jurisdiction because, why? Because there is no international consensus on the definition of terrorism or even its proscriptions. Yet, a minority view exists to the effect that terrorism has already been defined by international customary law. In an article published about a decade ago by the late Antonio Cassisi, a distinguished professor of international law at the time, he wrote, "Contrary to what many believe, a generally accepted definition of terrorism as an international crime in time of peace does exist. This definition," and still I am quoting him, "this definition has evolved in the international community at the level of customary law." Now, more recently, in 2011, about probably 6 or 7 years after he wrote that, the Special Tribunal for Lebanon, or STL, a mixed tribunal established to prosecute a local crime under Lebanese law, issued an opinion in which it concludes that a customary rule of international law regarding the international crime of terrorism, at least in time of peace, has indeed emerged. Now, this pronouncement is exactly or very much concordant with Professor Cassisi's opinion. But there should be no surprise there. Why? Because Cassisi, by that time, had become the president of the STL and acted as the judge rapporteur who drafted the STL opinion. In describing what constitutes the international crime of terrorism, the STL identified the following 3 elements: the perpetration of a criminal act or threatening such an act; 2, the intent to spread fear among the population, or directly or indirectly coerce a national or international authority to take some action, or to refrain from taking it; And 3, the act involves a transnational element. In other words, in order to fight terrorism, it has to be international terrorism. So if something happened within the country, it doesn't apply. And I don't know under this definition whether we can talk about ISIS being, whatever they are do, as being terrorism that can be prosecuted on the international level. If we were to take the STL opinion at its face value, the crime of terrorism should be an international crime and would be by now working its way to be included within the jurisdiction of the International Criminal Court, along with the crimes against humanity, genocide, war crimes, and the newly added crime of aggression. A member of the Department of International Law at the Military Advocate General Corps of the Israeli Defense Force seems to cite the opinion of the STL to argue for the prosecuting of terrorists before the International Criminal Court. Despite the STL opinion and its supporters, we are still, I think, very far from being able to use the international criminal law as an effective tool in the fight against terrorism, or claim terrorism as an international crime under international customary law. First, it is probably reasonable to suggest that a rule outlawing all acts of terrorism has emerged under international customary law, because the many specific anti-terrorism treaties, such as the International Convention Against the Taking of Hostages, the International Convention for the Suppression of Terrorist Bombings, the International Convention for the Suppression of the Financing of Terrorism, and another 12 or 13 similar conventions, and also because the plethora of UN resolutions and pronouncements requiring states to take certain specific actions in matters related to terrorism. But such a rule outlawing terrorism is not sufficient of and by itself to make terrorism an international crime. As Kay Ambus, chair of international criminal law at the Georgia Augusta University in Germany, and Anina Timmerman explained in their comments on the STL opinion, they said, while it is difficult to disagree with the chamber, meaning the STL court, as to a primary customary rule outlawing terrorism and the ensuing obligation of states in its preventions and suppression, it is a different matter to infer from this prohibition, without further ado, the existence of a secondary rule in the form of an international crime of terrorism. Second, it is counterintuitive to assert that an international customary rule defining terrorism has emerged while the United Nations has not been able to agree on what terrorism is. And if we go to the various pronouncements and treaties that have been adopted by the United Nations, we find different, even now, different definitions. I just would give an example. In the Declaration on Measures to Eliminate International Terrorism adopted in 1994, the General Assembly defines terrorism as criminal acts intended or calculated to provoke a state of terror in the general public for political reason or political purposes. Now, the International Convention for the Suppression of the Financing of Terrorism defines terrorism as act intended to cause death or serious bodily injury to a civilian or any other person not involved in war, when the purpose of such act by its nature or context, is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. Now we can notice that there is some elements that are common among all these definitions, but there is no one definition. And why terrorism should be only prosecuted when it has a transactional or it is addressed against a government and not other acts of terrorism. Third, regardless of what definition is adopted or agreed upon, what terrorism is. The word terrorism and the meaning of the crime appears to be evolving and changing in a rapid pace. I wonder, for example, whether any definition of the foregoing definition would be able to capture all the acts that the civilized world today consider to be acts of terrorism. For example, let us take the killing of Christians and Yazidis who refuse to convert or pay the jizya as demanded by ISIS or ISIL. Would such killings be covered in any of the foregoing definition if the real motive behind the killing was the distorted belief of the killers that their action is required by the command of God? I don't think any of these definitions would capture that. And they are not killing them to influence a foreign government or to spread fear among the population. I mean, we have to assume that there are certain killers who believe that they are carrying the word of God. But let me close by asking a challenging rather than a rhetorical question, and this has nothing really to do with the law. Are we really determined to fight terrorism as one of the most serious crimes of our times, no matter where, by whom, and for what purpose it is committed? The evidence is less than clear on this point. In a recent speech at Harvard University, probably all of you know of it, the US Vice President revealed that Washington's biggest problem in fighting ISIS and other terrorist groups in the Middle East is not the rebels fighting in Syria and Iraq, but rather the United States allies in the region. He named 3 countries as being so determined to take down Assad that they started a proxy Sunni Shia war, supplying cash to those fighting the Syrian president. Now, this candid revelation by the Vice President, who is known to be candid, raises another question. Could really 3 of our closest allies in the Middle East supply terrorist groups with cash and probably other material support without our tacit approval? Thank you very much.
Thank you very much. Obviously, I think the case that you try to make, that even now there is no universal consensus who the enemy is, and so on, and this is part of the debate. I think what is really important to see that at least one of the doctrines of international law, in Latin, the rebus sextantibus, meaning that circumstances change, and therefore the approach has to be changed. And I remember very vividly that because of the escalation of contemporary terrorism from the 70s on, even the International Committee of the Red Cross, whose mission, as all of us know, was to protect the victims of violence during wartime, they changed their approach because of the situation on the ground, is also to protect the victims of violence in time of peace. So the point I'm really making is that for a long time, even military officers in San Remo seminars and all this, they had to adapt to circumstances. Now, our last but not least speaker, commentator on these issues, it gives me great honor to introduce Ambassador Javier Perez. For him, I'm sure it's not only a question of definition. He was a victim of terrorism, actually kidnapped by the ETA terrorists, and was a hostage. So he knows exactly from personal experience what it is. We were very, very proud to have him and to have his continuing support of our academic work as a very distinguished diplomat serving as the ambassador of Spain in the United States and other countries around the world, all the way from Finland to Ethiopia and elsewhere, representative of Spain in international organizations, including NATO. And in addition to his rich diplomatic experience, he also excelled in the academic work in terms of writing, and also a distinguished journalist. So no wonder why he was awarded many, I think, medals around the world, and he also played a key role, I think, the first one, to be the Assistant Secretary General and Director of Counterterrorism of the United Nations, the Security Council. So I ask Ambassador Perez to share some of his views on this very complicated topic.
Thank you, Professor Alexander. Thank you, Professor Wallace. Indeed, it's an excellent occasion. I've been listening to you all with great attention, and it's a very thought-provoking round table, the one we have in front of us. Thank you very much for your contributions. I'll try and be brief because there is nothing much I could add to what I've been listening to, but let me throw on the table a couple of thoughts. And I will take up there where Professor Saliba left it. He asked why there is no definition, there is no common definition of terrorism in the international community. I think the answer is not a legal question. It's not a legal answer. It's a political answer. Because there are a number of countries which still consider the terrorism, the terrorist is terrorist for one and the freedom fighter for the other. And we are still there. We are still there. There are 192 countries, and some of them still are there. And then that reflects a deeper and even bitterer question, is that some of those countries do practice terrorism and do help terrorism. You know that very well, and we all know that very well. So the elements of the definition are there. The violence against civilians by non-state actors with the purpose of achieving political goals are there. It's true that the definitions do not necessarily coincide, but we don't need a coincidence because, we have, first of all, we have around 25 international agreements signed and ratified within the General Assembly about terrorism. So all the practical, all the concrete cases of terrorism have been contemplated by the international community. And second point, if you go through all the resolutions of the Security Council, not the General Assembly, because you could always say, well, you know, the General Assembly is just poetry. No, the Security Council is not poetry. And most of those resolutions have been adopted under Chapter 7 of the Charter, which means that eventually the international organizations could decide to use violence to those violating those texts. We all know that. And even in some, well, I remember very well 1373, Resolution 1373, which is the Carta Magna of terrorism. And you have there the definition, the purposes, the description, the cases, the obligations in international cooperation and so on and so forth. Everything is there. So if we haven't been able, and certainly in these more recent times, the Security Council has been producing a number of significant resolutions in terms of the violent extremism and so on and so on. So practically everything is. So what is lacking there is political will. That's the world we are living on. So that's the first part of it, and certainly we have to live with that. But the second point is some, if you want, more legal, if you want. And I'm extremely glad that this panel is talking about terrorism and international law. Because from terrorism to war crimes, well, unfortunately terrorism was not included in the Rome Statutes. And I was not involved. I'm not a lawyer by profession. I was not involved in those discussions, but there were a number of countries which wanted to introduce terrorism as one of the 3 or 4 crimes to be considered in the Rome Statute. Unfortunately, it wasn't. Now, some countries are asking for that statute to be widened, to be broadened, or eventually to consider a special tribunal to consider the crimes of terrorism. I know very well they're talking about the statute. The Rome Statute is rather sensitive in this country, but let me tell you that I wish sincerely the United States of America might eventually overcome the legal and political problems that you've been facing concerning the International Criminal Tribunal or Court and join it, because that would be a great boost for international law. And we all believe in international law, and we all believe in the merits of international law. But regardless of whether the Americans are going to join or not, there are a couple of cases where I would like to make the case in favor of international law through the Rome Statute, the International Criminal Court. Well, first of all, the International Criminal Court can go against individuals, which is something new in international law. The International Court of Justice was not able to go against individuals, it just states. This one can go against individuals. And there is one particular case where the ITP is doing a magnificent job, which is the case of Colombia and the FARC. Because FARC are individuals, terrorists. And on one side, they cannot be considered to be members or to be objects of the court, but the prosecutor within the International Criminal Court is talking about war crimes, and is accusing them of war crimes, which is not something excessive. I mean, it fits very well what those people have been doing all these 50, 60 years, war crimes. Or if you want, and that could be another interpretation, crimes against humanity. Why not? So there we have one case where international law, a recent or rather contemporary international law, is being rather effectively played to go against people who could be construed and should be construed as being terrorists. That's one thing. Another thing, what to do about those ISIS or Boko Haram killing Christians? This is genocide. This is clearly genocide. And genocide is included within the Rome Statute, within the International Criminal Court. And those are individuals. So certainly, I don't know exactly what is going to happen or whether anyone is going to use that, but certainly could be used. Even the prosecutor within the International Criminal Court could go against all those people. You could tell me, and many people could tell me, well, you know, before anything is done, will take ages. Well, probably will take ages. But I can tell you, in the case of Colombia, those fact terrorists are extremely concerned about what might happen to them. And the Colombian government is extremely concerned as well because the ITP has been telling the government, you cannot go around with impunity. Those people have to pay for their crimes. So, is a revolution? Perhaps it is not. Is it the beginning of a new approach to international law? I'm sure it is. I'm sure it is. And the final point, when listening to our Georgian colleague, with a lot of sympathy, by the way, a lot of sympathy, because what we are watching in Georgia, in Moldova, in Azerbaijan, and certainly in Ukraine is extremely serious, extremely serious. And I cannot go as far as to say what is going to happen there. Certainly I'm extremely concerned that goes beyond what we have been discussing here. But again, international law should be the reference just to try and see what happens there, because that's aggression. That's aggression. Aggression in the case of Georgia, aggression in the case of Moldova, aggression in the case of Azerbaijan, aggression in the case of Ukraine. And certainly it's not just my desire to pinpoint to the Roman Statute. It's a violation of all the rules, all the rules of international law that we've been trying to live by in the last 50 years after the Second World War. So I think it's, from that viewpoint, war crimes, genocides, war, crimes against humanity should be put together with terrorism, because those are, regardless of we can discuss and define and find a definition or not for who is who and what is doing what, all those, the actions that are provoking instability in this world of ours. And I think we should be extremely careful when looking into those matters and try to take a definite action in that respect. Well, thank you. Thank you very much. Thank you.
You know, usually at this point we begin a discussion for an hour or two, but unfortunately we cannot today because we have an event at 4 o'clock. I want to thank all of the panelists. As is often the case, as is always the case, Yonah has a way of bringing us panelists who then feel inspired to say things, and the result is very impressive. I think you'll all agree. So Yonah and all of my colleagues, our colleagues, thank you very much. Thank you.